Hi, this is Alan E. Kaye. I'm an immigration lawyer with over 35 years experience. We'd like to welcome you to our program, Immigration and You. Hi, welcome to Immigration and You. My name is Alan E. Kaye. I'm an attorney whose practice is limited to immigration, naturalization, visa, and consular law. I've been doing this for over 35 years. And on today's edition of Immigration and You, I'd like to talk about fiancé visas. Fiancé visas are also called K-1 visas. It's a non-immigrant visa. It's a situation where an American citizen files papers with the Immigration Service, technically with USCIS, the United States Citizenship and Immigration Services, and says, I am engaged to this person. This person is overseas. We're engaged. We're going to get married. So the fiancé visa petition is filed with USCIS. When and if USCIS approves the visa petition, it's sent overseas. The fiancé then goes into the American consulate for an interview. If the American consul is satisfied, they will issue the K-1 visa to the fiancé. If the fiancé has children, the children will get fiancé visas also to go along with the mother or the father. Now, the next step is the fiancé comes to the United States. He or she arrives here on the K-1 visa and is admitted for 90 days. And the government gives you 90 days to decide if you're going to get married or not. If they get married within 90 days, another set of papers is filed with the Immigration Service to adjust status, to change to permanent resident. And then within 6 months or so, they're called for interview. And if the interview is successful, the person then becomes a permanent resident. The fiancé becomes a permanent resident, and the children also. Now, that permanent resident card is a 2-year card. It's called conditional residence. And at the end of 2 years, you're supposed to come back and file another application to change the 2-year conditional residence status to a permanent card. Permanent cards are good for 10 years. This is called an I-751, which again is filed 2 years later. The government lets you file 90 days before 2 years. So at 1 year and 9 months, you're filing to change your temporary card to a permanent card. The question then becomes, what happens if at the end of toward the end, or even after you got your temporary card, you get divorced? Well, all is not over. People think, oh, I'm going to get divorced, I'm going to lose my green card. It's possible to file yourself, if you're divorced, to change the temporary card to permanent card. You don't have to wait the 2 years, but you have to show the government the same thing you'd have to show if you were still married, that this was a real marriage. The system requires that the government wants one more look to see if it's still real. If it was a real marriage, they want to see a lot of documents. So you're filing 2 years later if you're still married and living with your spouse and you're both signing, or if you're divorced, then you're filing yourself to change to permanent resident. Thank you for listening. If you have further information, any questions about fiancé visas, feel free to call me, email me at the address shown below. We'll be back at our next program, probably talking about employment-based immigration.